Sleep probably. That's not it's like so nice. Wake up late.
Saturday night. He was born, that guy might have been his brother.
Thank you.
He's a brother?
Yeah, but at this point I feel.
Well, I don't know.
That's not.
Hey, by the way, I think that
Because I don't want to.
Hey everyone, we're going to get started. Thank you for coming today to this meeting of the Federalist Society. Today we're lucky to have Mr. Walter Olson here with us. He's a commentator, an author, and a critic best known for his opinions on American law.
Yeah, I got a second.
He's a senior fellow at the Cato Institute Center for Constitutional Studies. And on the internet, his work can be found at overlawyer.com, a blog that he founded and continues to run to this day. It's one of the oldest, if not the oldest, legal blogs on the internet. And he's here to talk about his latest book, Schools for Misrules, Legal Academia in an Overlawyered America. And this book takes a look at the ideological trends in law schools and the effect that those have on the real-world application of the law. So please welcome me in joining him.
Thank you, Matthew. Can you all hear me? Am I loud enough?
Yes, for sure.
Okay. Well, some of you may have seen the story in the last couple of months about the lawsuit filed on the West Coast by PETA, People for the Ethical Treatment of Animals, against SeaWorld, the San Diego Ocean Zoo, for enslaving killer whales. And they said this is a constitutional lawsuit under the 13th Amendment, which bans involuntary servitude. And it sounds like a comedy routine, but the Associated Press took it very seriously and ran a long article explaining that it was important because it is the continuation of an ongoing intense debate at America's law schools on the expansion of animal rights. And indeed, as they went on, they quoted law professor after law professor, all of them in favor of what PETA was trying to do. A professor from Rutgers contends that animals deserve the fundamental right to not be treated as property. A professor at Michigan State has proposed a new legal category called living property as a step to providing rights. And none other than Lawrence Tribe of Harvard, hard to get more prestigious than our leading constitutionalist, had kind words to say also, although he worried that the courts were not ready yet for this particular leap into 13th Amendment jurisprudence. But he argued that the 13th Amendment was written broadly to address unforeseen circumstances, such as America's law schools have been taking leave of their senses. I added that last part myself. Well, not to spoil the end of the story, but a court did throw it out summarily just a week or two ago. And we have here a phenomenon. The original working title of my book was 10 Bad Ideas from the Law Schools and How They Changed Our World. And as Matthew mentioned, I've been writing about this for quite a while. If you turn to overlawyer.com, you see 4 or 5 new stories a day about odd things that our litigation system does, or strange new theories on which you might be found guilty in the criminal side of the law. And if you trace these back, especially the more extreme ones, you will find more often than not that there was some academic in America's law school proposing it 10 or 20 or 30 years earlier. Certainly, if you are bothered by the state of our tort system, Dean Prosser on torts had as much to do as anyone with why our tort system is the way it is. If you are worried that our employment law makes it too easy to sue over a job and too hard to know that you are behaving safely as an employer. Academics shape that very intimately. If you wonder about hostile work environment law and the tendency to worry about getting sued for telling jokes, Professor Catherine McKinnon kind of developed that one on the back of an envelope. And on. The book indeed has various chapters devoted to areas of law, some very successful, which did revolutionize the law, others failed attempts. Slavery reparations, for example, was an idea very much hatched in law schools. The leading public spokesman for it was Professor Ogletree, head of clinical programs at Harvard. And when it reached the outside world in the form of the courts, it fell flat in its face. The courts had no interest whatsoever in entertaining that litigation. There was somewhat more success for another of my case histories, Indian land claim litigation, which wound up producing 30 or 40 years, which continue to this day, of very intense political controversy and legal controversy here in upstate New York. This is the big Syracuse involvement in my book, because I'm somewhat critical of not just the way that the law schools, if law schools had only sat aside during the controversy, I guess it would have been better. They virtually unanimously lined up on the side of the tribes that were filing lawsuits for land that they had not occupied in 200 years, and clouded the title of various people who had family farms that they had handed down through their family for the same period. A dreadful example of how law can ruin a lot of people's lives and livelihood without really producing all that much benefit for anyone, except, I suppose, casino leverage. And something that law schools, I think, should have spoken out against, except that they were unfortunately all on the tribe's side at the time. Well, it is big issues that ruin people's lives, and it is also kind of small, fun issues. I don't know how many of you have followed the debate over looksism in the workplace. This is the type of discrimination by which employers, and this has gone on since time immemorial, obviously, employers tend to prefer job applicants who are really great looking over job applicants who look more like, for example, me. And this had been going on throughout all recorded history since this law has been master and servants, and not until roughly the 1990s did anyone think that this should be subject to a lot of causes of action, that the law should jump in with chances to sue people. And then the Harvard Law Review, around the late 90s or so, published one of these interminable law review articles that so often does mischief in the world, and it argued that looksism was a terribly important problem, and that the law needed to develop new discrimination theories to cover it. My favorite were the practical recommendations, which included not only wider use by employers of telephone interviews, but also wider use of interviews held behind screens, as at a symphony orchestra trying to be first violin. Well, the interviews behind screens idea has not, I'm sorry to say, caught on yet. I'm sorry, because it was such great material for open lawyer if it did. But we have progressed a good distance of the road down toward looksism as a cause of action. Many individual jurisdictions have passed such laws, including the District of Columbia, where my Cato Institute is located, and where the best case that has come along so far was a young man who lost his job at a retail outlet because his facial jewelry was so extensive as actually to inflict a speech impediment on him. And this is what got me fired, he told the reporter. And, you know, I laugh at these, but the fact is that that article helped make one of the most sensational careers in legal academia. The author of that article went on to write editorials for the New York Times about law for several years, wrote for Time magazine, and is now teaching at Yale Law. So if you are thinking of going into legal academia, you know, don't do one of the sensible, modest synthesis of what judges are doing type of articles. Do one of the completely off-the-wall things. It will give you a much better chance of establishing yourself at Yale. Well, eventually I had to abandon the 10 bad ideas in the law schools format for the book. I had no answer to the question, why stop at 10, Mr. Olson? How long is this book going to be anyway? And I could have gone on to include 100, but I thought it was more interesting to identify the patterns of why certain types of bad ideas are so popular, why they just keep coming out, even after being rejected often by real-world judges and lawyers, because it is certain kinds of bad ideas. And part of it, maybe not the most interesting part, is ideological. I mean, this is a Federalist society, so I'm probably not going to shock anyone too much when I say that law schools are not especially hotbeds of libertarian and conservative thinking. They just aren't. If you go around to, especially the more well-established law schools, and judge it by party registration or by who they donate to, which is a matter of public record in campaigns, you may find that it's 4 to 1, 6 to 1, 8 to 1, 12 to 1, Democratic over Republican. But that's imperfect. That doesn't exactly map onto actual ideology. But no one denies the general imbalance. Harvard is said to have gone for 30 years without hiring a single Republican to join its law faculty. And during much of this 30 years, there was actually a faculty standing committee on diversity. It just perhaps wasn't asking all of the right questions. But, and I will admit also, as a loyal Federalist, that things have been getting better. Maybe 15 years ago or so, if you went around to the better law schools, it would have been very common for you to not find a single, not even one, outspoken libertarian or conservative on that law faculty. And now that it would be unusual. If you go around more often than not, you would encounter one. It would be dangerous, of course, for them to hire more than one conservative or libertarian. They might begin breeding. But usually there will be that one. So they recognize the diversity issues involved. And how it got that way is something that I go on about in the book, and we can go on about it. But certainly it has its roots in history. The early 20th century saw Roscoe Pound, the most prominent legal intellectual of his day, saying that law was applied social engineering. That kind of sets up premises that suggests that you have one kind of law school rather than another. Maybe you are training kids to be social engineers. The real turning point, or at least what I point to in the book as the symbolic turning point from my point of view, came in 1943 with an article in the Yale Law Journal, Legal Education and Public Policy, by Harold Lasswell and Myers McDougall, which was to become by far the most cited article on legal education, on the mission of law schools ever published in America. And the authors were a distinguished pair. McDougall was a very well-liked professor of international law at Yale. Harold Lasswell was someone who was a household name in his day. He was a political scientist. He was head of wartime propaganda under FDR. He did a lot of influential work in many different areas. And when they were writing this in 1943, there had just been this constitutional moment that you all learn about in common law, these switch in time that saved 9. Up until just a couple of years earlier, the Supreme Court had said, massive government intervention in the economy is mostly unconstitutional. We're not going to let it stand. They had changed their mind. They didn't want to have court packing. They said, go right ahead, start doing it from now on, and we're not going to object. And sure enough, especially after Pearl Harbor Day, by 1943, the government had indeed taken over direction of the American economy. It was really giving orders to everyone. It was an unrecognizably different political economic system than 10 or 15 years earlier, and yet, and here I'm picking up the Lasswell-McDougall argument, and yet if you turn to the curriculum at law schools, it had not changed a bit. It was basically the same curriculum as in 1920 or 1910. It still was aimed at training lawyers to be private lawyers, working on Main Street or working for large enterprises or working for affluent people, resolving their disputes, arranging their deals, conserving their wealth, indeed conserving their wealth from the government, which is not how they wanted to continue doing it in the Lasswell paper. such matters as how bills and notes and how to replevy a dog and so forth. They were quite scornful. What was needed instead, the article argued, was a curriculum oriented toward achievement of democratic values as determined in reference to social objectives. It is nominally vague, and I always get suspicious when it's that vague. But they went on to become more specific. They said, we need to de-emphasize contract and property and courses like that, which they sniffed at as much favored instruments of the laissez-faire society. If you had to have a course in property law, they said, why not take the development of public housing projects as its jumping off point? Trusted estates, how passé, they said. In the future, it is mostly going to be government policy that determines how, if at all, property passes from one generation to another. Local government law, they said, law schools should instead be training lawyers in tasks that would fall to them, such as devising innovative forms of regional government like the Tennessee Valley Authority. They were even more discontent when it came to the public law courses. And here the air quotes are there, it's not mine. The so-called public law courses, they wrote, are still organized with too much deference to separation of powers, due process, equal protection, interstate commerce, etc. Well, this is wrong on so many different levels. I can't stop to go through all of them, but let me just start by pointing out how bad it was as prediction. If you were trying to equip new lawyers with a toolkit for the type of practice that they would actually be called on to do after 1943, it was a pretty bad idea to train them in how to lay out public housing projects. That remained popular policy for another 10 or 15 years and then became very unfashionable. So, likewise with forms of regional government like TVA. No lawyers wound up being employed in that area after another 10 years had gone by. And more or less every single one of the areas that they said should be de-emphasized turned out to be vitally important in what lawyers do, and vitally intellectually important, even if you're just going to be thinking about the law. Certainly separation of powers, equal protection, due process, and so forth were to become, if anything, more important in the years afterward. And there's a point here I'd like to step back and sort of warn you about, which is that anytime you hear anyone saying that law schools need to be de-emphasizing one area and gearing up on another because that's where the practice area will be in the future, ignore them, because all such predictions tend to be falsified by later experience. In the 1960s, there was a lot of talk about how there would be less demand for family law lawyers because, after all, we were introducing no-fault divorce, and there wouldn't be anything for people to argue about after divorce. Once you had no-fault divorce, would use it. They thought that we wouldn't need as many auto accident lawyers because the policy appeal of no-fault auto insurance was so obvious that states would all adopt that and the tort law would be unemployed. I mean, that prediction after prediction, grossly off the mark. In the 1970s, they said that we would need lots of energy lawyers, and then Reagan decontrolled oil prices, and all of them had to find new areas of practice. But so, on a prediction level, it was completely off base, and yet it was so influential on various other sorts of dimensions. Part of it was clever, which is that it wanted to change the direction of the law. At that point, the courts were dragging their heels and were not changing it. So you would just retrain law students in the way the law ought to be, rather than the way that it still was. They stopped teaching all of these things about contract and property. And a generation of lawyers would grow up who didn't have as much mental furniture as automatically analyzing situations in those terms. And indeed, law school people were not afraid of the charge of indoctrination. They said, after all, doesn't the old curriculum indoctrinate too in the assumptions of the old society? Well, the program of that article was so radical that no one adopted it. No law school, not even Yale, adopted the program recommended in the article. And yet, something had changed. The law as it is was down in prestige. Law as it should be was up in prestige. And that has lingered continuously to the present day. It remains true that if you want to get tenure as a law professor, you are better advised to write an article about law as it should be than law as it is, however brilliant the latter may be. But although, as I say, no one adopted the program whole, about 10 years later, Yale Law School did something that got everyone's attention in legal academia. It was so dramatic, it was so unusual. They dropped property as a required course. And almost no one thought of imitating them because of the obvious reasons. Property law was a cornerstone of the bar exam. It was vital, as it remains vital in all sorts of areas of real-world practice, and of course it was really, really hard. And so everyone else, or almost everyone else, went on requiring it. But the Yale view was, hey, we're Yale. We have students who are so clever that they can study that stuff in their spare time, or when they're cramming for the bar. And in the meantime, think of how many classroom hours we will open up for us to all discuss how future Yale graduates should run the world. And this tied in with the stereotype, and I have to say the stereotype of Yale Law School back in the 1950s was exactly the same as it is today, which is that yes, it was the most prestigious, and yes, it got the most brilliant people, but at the same time, it really was kind of the last place you would ever want to turn if you needed to get someone evicted or needed to bail someone out or some actual practical legal job that had to be done. It was not until later that someone composed the actual Yale Law Anthem, which with your permission, I will sing just one verse of the Yale Law Anthem, which goes, "Don't know much about property, don't know much about bankruptcy, don't know much about secured transactions, don't know how to file legal actions, but I do know philosophy, and I know that with my Yale degree, what a wonderful world this could be." Well, about a year ago, Malcolm Gladwell did a good article in the New Yorker on the craziness of competition between law schools. And let me just say parenthetically, I was not prepared when I started out researching this book for how obsessed with rankings, how fantastically jealous the law school world was, where faculty and administrators obsess on the difference in numbers 17 and number 19. Oh my God, we're number 32 when we should have been number 30. And you could compare it to debutantes at a cotillion, but that would be very unfair because debutantes at a cotillion keep things in much better perspective in my experience. It's just a dance, they don't get themselves so hot and bothered. But for law schools, there's nothing to compare with how jealous and competitive they are. And Gladwell gets into, and so does my book, get into some of the structural reasons why this happens, and the craziness of the U.S. News rankings. A magazine doesn't even really exist anymore, except as a school rankings service, and the craziness of accreditation, which forces schools to do various things they know perfectly well are not things they would have done otherwise, no matter how well-intentioned. And Gladwell sums it up, I think, very deftly by saying that both of those forces, U.S. News and accreditation, have the effect of pressing all schools to be more Yale-like. They have to have a more research-oriented faculty. They have to have more bells and whistles, disciplinary this and theoretical that. And it is as if, when you think about it, it's very odd to tell everyone to imitate Yale. It's odd in the first place that the prestige structure, let's say we were at medical schools, and let's say that the most prestigious medical school was the one where the professors had the least idea what to do with an actual sick patient if they were confronted with them. But even if that is going to be the most prestigious model for a law school, saying that everyone else should be more Yale-like, the only comparison I can think of is if you looked at the world of entertainment and observed last year that Lady Gaga was the #1 grossing act, and then advised all other performers and entertainers, the classical musicians and so forth, they should be more Lady Gaga-like. No, the lesson is, in my view, just the reverse. Only Yale can get away with it. Everyone else should do what they do better. And yet I have to say that it really worked for Yale. From this point on, Yale generated even more influential scholarship and even more national attention. It wasn't long before Charles Reich published his article, The New Property, which became the most cited law journal article ever. And it dovetailed rather nicely with the Laswell theories, because Reich argued, even as we are properly de-emphasizing in the law the old property, the real estate and the chattels and so forth. We need to lift up and use substitute property having to do with rights to go on getting government benefits, rights to go on being employed by the government if they would rather fire you and so forth. And it was fantastically successful. The courts and academics alike picked up on it, and it revolutionized both areas. Another 10 years, the law schools had served as the cradle of the public interest law movement. They had launched most of the litigation groups that remain influential today in influencing government policy by suing the government. And the focus was changing here in the United States. Under Loswell, the assumption was still that we were training law students to join the government, and by the time of the public interest movement, the assumption was we were training the brightest students to sue the government from the outside and force it to do things in consent decrees, which actually was a much cleverer way of doing it. But the history of ideas in law schools since then has been, you can read it as being an effort to repeat the hits of the 60s and 70s, not increasingly with less success as time goes on. The 1980s saw the heyday of the new constitutional law, in which it was argued that if you looked at equal protection and due process and other clauses of the Constitution, you might have to take your glasses off first, but you could find in there a judicial charter to require pretty much everything that the New York Times editorial page believes should be adopted, from higher education funding to right to health care and right to housing and so forth. And it was a great theory. It had a huge head of steam behind it, and then it ran into the Rehnquist and the Roberts Court, which did not like it so much. And I thought, I would almost say that was that, but it won only a few victories compared to the many that it was expecting. By that point, law schools were on to identity politics, which was so prevalent, especially in the 1990s, which made it increasingly hard to do anything in law without tying it in with one or another identity group. And I've mentioned some of the fruits of that, like the slavery reparations movement, which generally fared very poorly in convincing courts in the outside world. And if you ask what has been the enthusiasm of the last 10 years or so, I think there's one pretty clear answer that jumps out. I write about it in the book, which is international human rights. And it is certainly the fastest growing area as far as the number of professors devoted to it, the number of journals and conference series and litigation clinics and so forth. And of course, the content of international human rights has changed very, very drastically over the last 20 years or so. 20 years ago, it was seen as being, and it became incredibly popular as a field that devoted itself to dissidents in dungeons, to the kind of outrages in countries where they shut down the opposition newspaper and banned the opposition party. And that is still one important focus of international human rights. If you go to the websites of the Human Rights Watch and the various other big nonprofit, non-governmental organizations, you'll still find maybe 20–25% of their docket of interest is those traditional international human rights areas. But oh, is there so much more? Now you will find prominent campaigns on the international human right to adequate low-income housing, to fresh water. The other day, in the papers reported that a UN observer had ruled that the city of Sacramento was, in her view, probably violating international human rights by evicting a homeless encampment because it was violating their right to water and sanitation. Apparently a right to have that brought in, but now a right recognized by the United Nations. And indeed, you turn to almost any hotly contested policy area and you will find there being asserted major international human rights angles. Last year, when Governor Walker in Wisconsin had his showdown with the unions, and he persuaded the legislature to dial back public union rights to a more Virginia-like status. It was not the most conservative set of rules in the country, but it made Wisconsin a less liberal state than it had been. I lost track of the number of American law professors who said that what Walker was doing was not just a bad idea, it was not just something the voters should punish him for, was not just in conflict with U.S. labor law, in one way or another, but was a violation of international human rights of the public unions and their members. After Obamacare passed, and I will say I kind of sat out the Obamacare debate, I figured it was other people's issue, but after it passed, the Journal of the American Medical Association ran a letter from a Georgetown law professor and a co-author saying that this was a good first step in meeting America's obligations under international human rights law, namely to government guarantee of health. We should recognize that the U.S. was still out of compliance because Obamacare was not nearly as big and as far-reaching as it would have to be in order to put us into compliance with the UN's standards on government health care plans. And my reaction was, I guess I should have fought it after all. I thought it was just a health plan. If I had known that we were giving up national sovereignty, I would have objected. Well, if you were cynical, you might conclude that what's going on here is a bit of a replay of the new constitutional law, the failed new constitutional law of the 80s, in which it was thought that everything desirable on policy grounds from a liberal standpoint could be packed into the language of the U.S. Constitution. Now we're finding all of those same things again, that they're being packed into international treaties and human rights. Well, I promised to come up with a couple of the patterns that unite these areas. Virtually all of these ideas give the government more to do, and that, I guess, goes with territory. But they also give lawyers and judges more to do. It is not just that they want government spending programs. Those indeed are not particularly popular in the law review literature. Litigation programs are much more so, and new rights of action and new 14-point balancing tests and so forth. And that gives the future graduates, so it is hoped, more to do, and particularly it gives legal intellectuals like those who are indeed the faculties of law schools, gives them more to do. Friedrich Hayek put it very insightfully, I think, when he said that intellectuals have their own particular biases they bring to the world, and that when they approach public policy, one of the biases of intellectuals is in envisioning a greater role for intellectuals and their output than the rest of society tends to envision. And so it has been, I think, with the legal intellectuals that have been so influential in the last 50 years. What they have prescribed has been sometimes good news for graduates of their schools, even better news for in-demand faculty, but I continue to doubt whether it's such great news for the rest of us. Thanks. We have some time for questions, and I must have provoked some of you into react. Was that a question? No. No, really, anyone? Yes?
Yeah, I think in my experience, what you say about intellectuals usually trying to change society is definitely true in my experience. But don't you think it has to be like that? Because when something's already established, if you're an intellectual, it's almost, how do you go back? So if you're thinking about new things, it's inherent that you're thinking about things that haven't happened yet or aren't going to happen, and to try to come up with a way for it to happen.
Well, yeah. It's a good question, and I would say what has been missing in legal academia, which is not always missing in some of the other great disciplines in the university, has been a proper humility. In medicine, for example, obviously one wants to come up with new ideas for therapeutic interventions that could save people's lives, but at the same time it's drilled into the future physicians at every point. Look, surgery or medication or whatever has side effects, it's harmful. Think of the costs, be sure you're not doing harm beforehand. Hesitate before rolling out something that could wind up harming a lot of the people. In law, I mean, I haven't mentioned law and economics, but one of the things that makes me scream is when I see a law and economics analysis saying, here's our model and we're going to assume away transaction costs. Law is nothing but transaction costs, and all sorts of great ideas for what law could or should do wind up being harmful in the real world because the litigation costs swallow up the fine incentive effects that you were trying to accomplish by making the rule more complicated. And to the rest of the world, the costs of law, whether it be over-sweeping deterrence of things that weren't actually harmful but wind up getting banned, or the transactional costs of being swept into the incredibly miserable process of litigation because something was left unclear or someone needs to establish precedent on something. Those are what the outside world often thinks of first when it thinks about law. I wish more law professors thought of those things first too, the way a good surgeon will never operate unnecessarily. Yes?
But isn't it the case that with ideas, or specifically maybe ideas in the legal field or the economics field, that you're never going to have an idea or a social apparatus or an organization that's always going to be beneficial for everyone? There's always going to be a group that will likely suffer from the implementation of an idea. It makes me think that you might have objections to like utilitarian ethics, because that seems to me what kind of governs contemporary American law for the most part.
Well, yeah, and I won't go out on the uncharted ocean of whether utilitarian ethics should explain all of how we set up government. I certainly agree, and I'm sure all of us do agree, that sometimes a policy is called for and necessary, even though it produces a category of losers, and even serious losers. That having been said, if the frame of mind that we bring to the problem systematically underweights certain types of costs and losses, then we can expect to wind up with a biased set of, and that's all I'm saying. It's not that there should be a veto from some third party coming out badly because of the new rule, but that we appreciate how big the costs often are and how common it is in the outside world for the costs of legal process to terrify people out of rational courses of action. There was a question here.
To kind of take your med school analogy a little bit further, a lot of medical schools do kind of divide themselves between practical physician skills and research. Would you advocate a similar division in law schools where you have, law schools that focus on practical, lawyering skills, and then you have another separate set of schools that are more legal theory, how the law should be, as you said?
Yeah, I would recommend that, and that is something where you need to crack the accreditation nut in order to get the amount of differentiation that I think would be a good idea. There's no reason why you couldn't have law schools that de-emphasize the student experience because they saw themselves mostly as research shops, empirical or theoretical. At the same time, there are a lot of people who would appreciate having the option of a law school that cost not as much and was focused like a laser on the areas that will remain in a lot of demand in practice. And the medical school example, it has a lot to teach us in many ways, because I'm not sure why it works better, but there is much less of a perceived gulf between what the cutting edge, why do I use that? Between what the best surgeons and therapists want training to be and what the students are actually imbued with. Whereas in law, it's a cliche, the hiring firms, even though they come back and hire, they say we have to spend 1.5 years before they are up on the level of skills that we wish they had coming out of the schools. And there's so much room for obvious improvement that I think a consensus is forming fairly rapidly. One that certainly cuts across political lines. And I'd like to see more radical, I'd like to see attempts at doing without accreditation entirely and just using the bar exam as the gatekeeping function. That's still not in the cards in most places. But one other thing about medical schools is that someone has done a study on how important is medical school prestige? Because of course medical schools do have their rankings, and there are ones that are acknowledged as being the top of the heap. It was discovered that in predicting the future course of a newly graduated medical student, how eminent a doctor will that person be, the prestige of the medical school where they trained was like the 18th most important factor. And we know that in law, the pathology is much more ingrained. I mean, many opportunities will be given only to graduates at the top of a few law schools, no matter how brilliant a job someone's done one level down. And that also should be blown off through whatever means necessary. If not, thank you so much for your attention.
How was your alma mater?
It was an interesting.
Do you regret going?
No.
Anytime I go, I didn't actually go. Yeah, but you saw the people. I saw that. 42% of the party was people around. It's 7%. It's not. Oh, we're talking about.
And for participation, we'll start. It's like the whole one.
I know. Well, yeah.
saw that.
People need to do that.
You know?
Even like major
We'll start and present, and the participation goes down.
I'll see you later.
So this is like. That's cool. No, it's cool.
Do you have the book out with you, or am I able to just glance through it? Sure. Thank you. Oh, okay. And then also, you mentioned just at the end there, how you think how you would like to see non-accredited university try more of a practical model. Are any law schools in the US doing that right now? So it's just like a pure apprenticeship almost, no formal education?
Basically, and the thing is, I also look at other countries, and
Right.
in other countries, universities as such generally have a lesser role. Some of them allow reading law to apprenticeship law. others. Some things that is less than
Actually,
all major institutions followed by a master that is not previous law is a conflict. And you declare your preference when you're I just know that you absorb quite a bit of stuff which I'm interested in, and then you'll be another year or two. And as with doctors who are 4 or 5 years
Okay, and what, I'm sorry, you said Virginia, and what other states still have? I mean, is that a state law?
What this is, those are
Right.
following campaigns.
It wasn't just that, it was like really because there's like 3 or 4 like things.
So the idea was
It's like you said, it's the problem is that
Yeah, I didn't, luckily we had a way, but I wouldn't
they
even.
weren't just people, they throw in
If I could do it over again, I might have gotten it.
it's that
Is that an American Day Association?
they work through their north wall on his like elbow, which he walk around to like the things that he would it's just but it's just the
When you say that,
Hey, I think you didn't realize how this went down.
Yeah.
We just stood up and they gave it.
I know, right?
I have like that, and then my cover was like poetry copies or whatever. I don't have veils. My grandma would like almost in tears when we were living in more veils. It would frighten me. Yeah, I was like, I guess I'm really happy. Complete waste.
a lot of things
Touch those. It's like cool.
but see that's the
Never.
they're saying that based on his
Oh, man, gets big.
they're just not the right type of
oh,
Really?
that's what they were trying to argue is that they're saying that
thank you very much.
but that's what they were saying that's what they're alluding
Well, no, I mean, I don't know why. There's 2 people who where I slept.
Yeah.
I was from the National Guard in Utah, and I was from an active duty mobilization unit. And they were like right next to where I slept. And you walk out there and you tell the pressure what you on and you have to take the name of the roof and you have to turn off the pressure. But in reality, there wasn't really that much pressure on me.
No, because they're gonna. Yeah, no, we did ours together, and we did on Thursday, but like, there were a couple of days we did on Thursday, because I was like, I'm not having to take off your time. Oh, yeah. Absolutely. Really nice stuff.
There was a Korean camp down the street, there was Emirates camp down the street, Egyptian camp down the street, you can go in and eat their food. You can do acupuncture at a Korean kids that can go out and have a school.
What's she trying to schedule around?
That's like,
Might have been his first, yeah. I mean, not
Where is she?
Business hours.
The wedding?
they reach out to him. Everybody always has that one person that you, and you probably didn't have that one person.
She needs to coordinate whatever she's doing.
Some units don't.
Will be different.
They're still gonna look out for their studies, but they still need to be there. Yeah, so where,
I'm the only one who feels that way.
See you at Federalist things, I hope.
Yes, definitely.
and there is actually, that was the equal opportunity where people had issues with anything that has to do with any kind of discrimination, they, come talk to me and either address it or write a form.
I've been there a couple of
I should have known about that. Every source knows that from day one that might have to take up insurance. Maybe he didn't, maybe he was just afraid or something.
It's like a girl's nightmare. They're talking about guys and people and they're like,
Maybe that's why he actually
or it was yeah, and then they're like, okay, thanks a lot. And I'm like, so it's out and then she's writing to an attorney. Like, that was like 9 like, how could you even in good conscience walk that down? Like, I honestly thought that it was over after then. Wow. And I mean, I'm not saying that there aren't those
so I know where it feels like you're at, but
why they were asking about that?
well, because I came from Croatia, others and I mean, it just tells you the ignorance. I mean, okay, it tells you the ignorance of people like